All right, if you want to go ahead and call the case.
Yeah, please do.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Estate of Karen Jean Makas, case number 25AP296. Appellant Tony Clitheroe is self-represented. Representing the appellees, Darcy Bontempo and Kai Himberg, is attorney Angelina de Beaupuy. Present with attorney de Beaupuy is attorney Kevin Henry.
Okay, thanks very much, and good morning, everyone. Ms. Clitheroe, can you hear me?
Yes, good morning, Your Honor.
All right, good morning, and we can hear you. You understand you have 5 minutes, and we'll try to give you an alert when you've got about a minute left, so please go ahead.
Thank you, Your Honor. May it please the court. My name is Tony Clitheroe. I'm the appellant, and I'm appearing pro se today. I'm here to, answer any questions the court has. I think the matter has been pretty well briefed. I want to be clear that we're not asking for a de facto enlargement of the time to file a notice of appeal. We are seeking to have credit for the fact that a timely notice of appeal was in fact filed in a matter that appellees have conceded constitutes one matter. It's comprised of two dockets. And in fact, the only reason it's comprised of two dockets is because the probate court avoided deciding appellant's motion to dismiss for lack of subject matter jurisdiction by giving appellees an opportunity to pay a filing fee to open another estate case so that there was some appearance of jurisdiction to order an accounting. So the accounting was strictly with respect to a power of attorney for a deceased individual and was appellant contends improper, and no decision was ever rendered on that. So we're not seeking to extend the jurisdictional limits of the court. We're allowing this appeal is not going to cause the legal system to groan under the weight of uncertainty or cause litigants to embark on a never-ending cycle of litigation to try to argue about the equities against the equities of enforcing the law, as the Silanovich court decided in the Second Circuit. This case is not along the lines of all the Killington cases that were cited by appellees. This is more a Schuler, Shanty Point case. The issue is prejudice. That's really the only issue. And as a matter of law, this court can find that there was no prejudice. And indeed, appellees have conceded there was no prejudice. The standard of review is clearly plenary de novo review by the court. Not only is there ultimately a statute that's being construed, the 2383 in Title 12, but also Rule 3D1 specifically vests this court with the discretion to do whatever needs to be done to address an informality in a notice of appeal. I'm not sure what other issues the court may have questions about. I wanted to give the court an opportunity to let me know if there's something I should be addressing.
Well, you're free to reserve the rest of your time if you'd like.
Yes, I would like to certainly have some time for rebuttal.
All right.
Thank you, Your Honor.
Okay, thank you very much. We'll turn to the counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors, and may I please the court. My name is Angelina de Beaupuy, and I represent appellees Darcy Bontempo and Kai Himberg. The only issue before the court today is whether or not the probate division abused its discretion when it found that appellant failed to show excusable neglect and denied appellant's motion for an extension of time to file an appeal. This matter has been ongoing for 6 years, and the only relevant facts for this court's consideration are the following. On June 6, appellant filed a notice of appeal in the wrong docket and wrongfully appealed to this court instead of the civil division. On July 11th, this court dismissed her appeal, finding that she had failed to show that the appeal involved only a question of law and that the appeal period was not told by her failure to file in the correct docket. By that time, on July 11, the appeal period had run, and therefore the only avenue for appellant to appeal the probate court decisions was to seek leave to file an untimely appeal under Rule 4D of the Vermont Rules of Appellate Procedure, which she did. And the probate division reviewed her pleading, and based on well-settled law regarding the excusable neglect standard, found that she had failed to show excusable neglect. The probate division rightfully focuses attention to the only factor that is decisive and the most important one, which is the reason for the delay, and found that both mistakes committed by appellant do not constitute excusable neglect. Those mistakes were failing to provide sufficient information for this court to establish jurisdiction and failing to file before the right court. Those mistakes do not constitute excusable neglect, and based on this court own precedent, are not excusable. This court has ruled in the past on many times that a mere oversight or inattention to detail do not constitute excusable neglect. This court did so in Re Town of Killington, 176 VT 60. And as far as the rules, this court also ruled on multiple occasions that failure to understand the procedure or ignorance of law do not constitute excusable neglect. For example, they did so in Rule v. Tobin, 168 VT 166, and in Ray Land, 177 VT 465. The probate division's order of July 11th, 2025 is based on sufficient findings and well-established law regarding the excusable neglect standard, and therefore we seek that this court affirm the probate court's order. And unless your honors have any questions, I do not have anything further.
Okay. I don't see any hands. Thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 34 seconds remaining.
Counsel?
Thank you, Your Honor. So first off, the standard of review is clearly de novo review. Not only is there a statute at issue here that needs to be, for the court's construction and under 2383, but also, as I said, under 3D 1, and I'm going to mess up the exact site, but under Rule 3, the court has full discretion to decide what to do to address an informality and a timely notice of appeal. All the rule requires is that an appeal be timely filed. A notice of appeal was timely filed. Unfortunately, it was filed in a docket that did not have the tolling order.
You have 1 minute. Do you have 1 minute?
The only reason that the tolling order was not in that second docket was because the court had not filed the tolling order in the second docket, although the practice had always been that the parties never duplicated filings in both dockets. They only listed one docket number. The substantive orders were always filed in both dockets, except for this tolling order. So this worked to the great prejudice of appellant. The other occasion that was mentioned in the brief was the amendment to the accounting order. That was also not, that correction, that strike through was not filed in the second case, also to appellant's great prejudice. This docket, this case should be consolidated. It should be viewed as one case, like in Ray, the Shanty Point. I'd like to refer the court to page 7 of volume 1 of the
Okay.
of the appellate volume, where the court states that this is the same case. He said this initial case is the same case, Your
All
Honor.
right. All right. Thank you very much. Your